or you're in a business.
Good morning, everybody. Thanks for joining a bit early. We'll get started here right at 11 o'clock. Just wanted to make sure that you can hear me. If you have any questions about whether or not your equipment's working, now would be the time to do an equipment check before we get going.
All right, testing out the audio.
I can hear you.
Got you over here.
All right, good morning. I'd like to call this meeting to order of the Common Interest Community Task Force for Friday, December 19th, 2025. Welcome, everybody. We're on a couple of things here, so call the meeting to order and then we'll do introductions. But before that, I want to do read out the roll call. I have Amanda and Letty on as support staff, just so you're aware. Once we get through roll call, I think we'll use the same list order and we'll just do a brief round of introductions if everybody can introduce yourself and say, no longer than about a minute or so. Kind of your background would be great so we can all get to know each other. And then we'll move on to part B of our first agenda item here. So let's go to the roll call.
Letty Chavez for the record, Dr. Chris Sanchez,
Here.
Donna Zanetti,
Here.
Michael Buckley,
We got you, Michael. I see that you are
Mhm.
muted, but we see it.
Jason Horn,
Here. Good morning.
good morning, Assembly Member Heidi Kasama, Garrett Gordon, Doug Flowers,
Here.
David Barron,
Here.
Mark Leone,
Here.
Bill Sue,
Here.
Crystal Parkeegan,
Present.
Sonia Merriweather,
Here.
and Shara Sandra.
Here. Sorry.
I believe
have a
that's
quorum.
everybody. Thank you, Letty. I appreciate it. So utilizing that same list order, just because I think it's probably easier and what we have here, we don't want to miss anybody. I'd like to have you guys do a brief introduction about yourself, and then we'll kind of move into the next part of the agenda. I have Donna, if you want to go first.
Sure. My name is Donna Zanetti. I'm a partner with Leach, Kern, Gruco. We're a law firm that focuses on common interest communities, both up here in Reno, where I'm located, and down in Las Vegas. Prior to becoming an attorney, I was a community manager in Nevada and back in Maryland, way back in the day. So I'm very pleased to have been asked to join this task force.
Thank you, Donna. Michael?
Yes, thank you, and good morning, everybody. I'm an attorney at Fenimore. I've been involved, actually was involved in the enactment of NRS 116 and served on the commission for 8 years. And basically my practice has involved representing developers rather than associations.
Thank you, Michael. Jason?
Good morning, everybody. My name is Jason Horn. I am the owner and CEO of Taylor Association Management here in Las Vegas. I have been practicing as a CAM since 2003, and look forward to offering as much information and insight that I can to this committee. So thank you for having me.
Thank you, Jason. Assemblywoman Kasama? Garrett? Doug?
Hi, Chris. Thanks. Good morning, everybody. Doug Flowers. I'm a partner at Holland and Hart in the Reno office, also licensed in Montana. And getting licensed in Idaho, I've been drafting CC&Rs or reviewing them and working with community associations, principally from the developer standpoint, for the last 20 plus years in Nevada, now Montana and Idaho. And when I was told I might get to sit on a committee with August folks like Donna and Michael and Garrett, jumped at the chance. So thrilled to be here with you guys and happy to help in any way that I can, and looking forward to the process. Thanks.
Thank you. David?
Hi, my name is Dave Barron. I've been a board member in Reno and Las Vegas for over 10 years, and I'm very happy to be on this committee.
Thank you, David. Mark?
Hi, I'm Mark Leon. I'm the president of the board of Mountains Edge Master Association, which is a master HOA of about 12,000 homes in Southwest Las Vegas. And I'm happy to bring a board member perspective to this task force. Thanks.
Thank you. Phil.
Good morning, everyone. I am Phil Sue. I am a Senior Deputy Attorney General with the Business and Industry Division of the Attorney General's Office. I primarily represent the Real Estate Division and work with them to prosecute cases before the Real Estate Commission, the CICCH Commission, and Appraisal Commission. Appreciate the opportunity to serve alongside all of you, and I really look forward to having productive conversations and action points from this.
Thank you, Phil. Crystal.
Yes, good morning. I am the Senior Deputy Attorney for the Nevada Real Estate Division. Prior to that, I was a Deputy Attorney General representing the Real Estate Division before the Commission. Good morning.
Good morning. Sonia.
Good morning, Sonia Merriweather. I am the Ombudsman, and I have been with the CIC program for 24 years.
Good to see you. Sharath.
Good morning, everyone. Sharath Chandra. I'm the administrator here at the Real Estate Division.
Thank you. And I'm Chris Sanchez, Director of Department of Business and Industry. It's good to meet all of you and see you here today. And thank you for your patience. I know it took a little bit of time to get everything scheduled, and we had a little bit of a snafu in the beginning, and that we neglected to post the Teams link for an earlier scheduled meeting. So thank you for bearing with us. We'll move on to Part B of Agenda Item 1, which is review of meeting goals and objectives. There's a few things I wanted to mention. For me, at Business and Industry, holistically, one of the things that I'm really focused on is modernizing the agency. We're doing a lot of changes internally at BNI in terms of looking at how we operate, looking at our regulatory framework, kind of unpacking why we do what we do and how we do what we do. I view this task force as an extension of that effort, and looking across the industries that we regulate, learning from the folks that we regulate, learning from industry experts, learning from our general public, and bringing in that feedback to see how we can improve. And that's really kind of the ethos of what's driving having these task force meetings to see where there may be gaps. I think many of you are in this industry, you know this industry much, much better than I ever will. But one thing that I've gleaned from a lot of conversations is that Nevada's regulatory framework is quite strong. That we are a state that other states look at in terms of that framework. I think that bodes well for us. But even with that being said, I think that there's probably areas that we could enhance. And so I think one of the things that I'd like to achieve through this task force process is from all the different varying experiences that you all have, recognizing what works well, identifying where there may be gaps, hearing from the constituents and also, see where those improvements could happen. One of the things that I want to make sure that we do that before we get too far here is that we did receive, I'll address that here in a second in public comment. But we are encouraging open and respectful dialogue through this process. So please, do speak freely and let us know your thoughts as we go through. We hear from the various experts and folks that will be presenting out to us. This first meeting is really to kind of get a foundational level of understanding, from the administrator and from the ombudsman in terms of what they're seeing on as regulators and on the as they're administrating their offices and doing what they're tasked to do vis-a-vis statute. And then we will be bringing in folks that are experts in different areas for future task force meetings. Certainly would like to hear from all of you, and this is agendized as you've seen on the agenda, to see what agenda items you'd like to bring forward for future meetings. Just going through a mental checklist here. In my leadership here, one of the other things is I mentioned efficiency and one thing that's important for all of you to know perhaps about me is there's no sacred cows, right? So, we really want to drive government forward. Business and Industry, as you know, is comprised of 12 regulatory agencies, 67 boards and commissions. Much of the statutes that govern our agency have been tweaked on the margins. I'm not saying that holistic change is needed in any one industry, but I'm also cognizant of the fact that we do a lot of things incrementally in Nevada. And sometimes there is an opportunity, I think, to look at kind of more holistically at what we do and push where we need to enhance and drive change when necessary. and recognize where things are working well and also understand that maybe a change is not needed. So anyway, with that, I think if anybody would like to kind of from the group's perspective, if there's any goals or objectives that that you have in mind for this task force as task force members, if you'd like to kind of put those on the agenda now, that'd be great for our future reference as we're building out the discussion and dialogue for our future meetings. All right.
I'll speak up.
Please do.
I'll speak up. Michael
Sure,
Buckley.
please do.
Couple things. One is I like the idea of modernizing, and Sonia and I spoke with the RAND experts a couple months ago they were looking at different things, and it seems to me that modernizing disclosures and focusing on things that are really important, maybe updating the Attorney General disclosure form, that kind of thing would be helpful. The other thing that occurred to me is that when I was reading some of the public comments, it seems to me that there is already the ability of the commission or the division to prepare regulations that address some of these questions that come up. And I guess I'd like to see some clarity between or among the division, the commission, and the ombudsman, where exactly they fit and how they work together and what they should do. And also I think that would also include taking a look at some of the public comments did on the arbitration and mediation procedures. But I think that was those were things that crossed my mind.
Thank you, Mike. Any other thoughts on objectives and goals? All right, seeing none, we'll move on to item number 2, public comment. I'll turn it over to Amanda for facilitation.
Hello, everyone. So just gonna go over really quick our next portion with public comment. So just as a disclaimer, no action may be taken upon a matter raised under this item of the agenda until the matter itself has been specifically included on an agenda item upon which action may be taken. Comments will be limited to 3 minutes. I will have a timer that I'll share on the screen for each public comment. If you are making a public comment via phone, please call 775-321-6111, and the phone conference ID number is 735-112-509#. Additionally, I'd like to just mention, I'm going to read off the names of the folks who sent in public comment already. We've had public comments submitted by Paul De La Cruz, Michael Kosar. We have all 3 of the public comments that he sent in, Laura Chapman, as well as Jeannie King. And I will now turn it over back to the director.
Do we have any members on the teams that are wishing to speak for public? Any participants on teams that would like to speak during public comment? And Letty or Amanda, do we have anybody on the phone? Oh, I see. Hold on. I see a hand raised. Michael?
I will share my screen and you'll have 3 minutes for public comment. You can begin now.
My name is William Lovegren. Dear task force members, I am writing to formally express deep concerns regarding the current limitations placed on homeowners who rely on the Nevada Real Estate Division, NRED, for oversight of community interest communities, CICCH, and their associated homeowner associations. Nevada has approximately 642,411 HOA homeowners, whose assessments help fund NRED's operations. Despite this substantial financial contribution, homeowners continue to face significant barriers when attempting to file complaints or seek meaningful enforcement action. The current system leaves homeowners with little more than symbolic recourse while associations and management companies operate with minimal accountability. At this point, the situation demands a clear and decisive remedy. Homeowners deserve one of the following. One, real enforceable complaint powers, including transparent process, timely investigations, and the authority for NRED to impose meaningful corrective action when HOAs or management companies violate Nevada law. Or two, structural reform, including the dissolution of NRED's HOA oversight function and the return of those matters to the courts, where homeowners can pursue enforceable remedies without administrative barriers. The status quo is not serving the public. Homeowners are funding an oversight system that does not provide them with practical protections or effective enforcement. This imbalance erodes the trust and undermines the purpose of regulatory oversight. Thank you for your attention to this matter. I look forward to seeing your meaningful action that reflects the needs and the rights of Nevada homeowners. Sincerely, William.
Thank you so much. And we will move on to Mike Kosar. Your 3 minutes will start now. If you'd like to unmute yourself.
Can you hear me now?
Yes.
Okay, thank you very much. Sorry about that. I was looking for the button instead of the Control-Shift method. My name is Mike Kosar. I appreciate the opportunity to speak here. And first, let me say congratulations on your ability to actually get a meeting started here after many years that this has been dormant. I hope it will be very useful to the community, and I think it has a lot of potential promise. I do have some more technical questions as far as administration goes. Within the comments period, are there going to be a comment period prior to each of the agenda items, or will for instance, all 5 comments on the agenda now, will they have to be done here in the beginning, which would be about 1 minute per area, or can we expect that up at each agenda item?
There will be 2 opportunities for public comment as listed on the agenda. This one here, and then later in the agenda before we adjourn.
Okay, well, I've submitted comments for each of those. I would ask that the committee rethink that because frankly, when you stack the agenda and you have 5 items on it, the ability to comment for each of those then is limited to about, as I said, about 30 seconds per item. And that really doesn't provide much in the way of comment. I've provided most of my written comments to you. Hopefully everyone on the committee's had an opportunity to read them. I will like to reemphasize what Mr. Buckley said. Disclosures is very important, but I see ADR being a huge element that this task force needs to get into and how we correct some of that. And then more importantly, and also, I too don't see the distinction here between what the CICCH task force is doing, what the CICCH commission should be doing by statute. And I don't see the distinction here because what's on the agenda now, I see all of them should be within the reach of the CICCH commission. And really, I would like to see this task force actually do some bigger stuff in the way of ADR and things that would actually take legislative reform to get through. Thank you very much, and I'll be interested to hear what everyone has to say.
All right. Anyone else for public comment?
Yes, I'd like to.
Can you please state your name?
I'm listed as Solomon Bradley. I go by Will Bradley.
All right, your 3 minutes starts now.
All right, hello, members. I'm a past board member at CICCH Las Vegas, and currently just a owner that helps to provide oversight of my board from a concerned owner perspective. I've run a concerned citizens website for my 45-story building called skyhomeowners.com. There's some very interesting information I've posted under there under a tab called current HOA scandals. I encourage everybody on here to go look at that. One of our scandals is we're being investigated right now by the Federal Department of Housing and Urban Development for religious discrimination, as well as the Nevada Equal Rights Commission. I know that's out of NRS 116, but it could go to fiduciary duty of boards that make terrible decisions that get themselves investigated by federal agencies that cost homeowners tens of thousands of dollars in lawyer fees. I wouldn't call that fiduciary in any way, which could be related to NRS 116. Principally, though, serve as a assistant to Senator Carrie Buck. I'm an unpaid volunteer assistant to her. I'm a licensed lobbyist or registered lobbyist with the state of Nevada because this issue is that important to me. Better governments by HOA boards and better enforcement. You only get what you inspect. You only get what you enforce. And HOAs are set up to be great instruments, but we all know they're run by some people that are either greedy or power hungry or both. And so they make terrible decisions sometimes. And so the average owner relies on the state to properly regulate them. And I don't see that happening. I agree with the first commenter that we have to have better enforcement and regulations. So some people are going around already to the courts. Judge Jessica Goody, as a matter of fact, does hear HOA instances in her court, in small claims court, otherwise known as justice court, because of her concern for issues. And I'll point you to two HOAs that failed in Henderson recently, causing the city of Henderson to bail them out because they didn't have good enough reserve funds with city taxpayer dollars. I mean, it's a crisis. We could tell each other we're the best state people are looking up to, but HOAs are in a crisis, and I hope this task force can find a better way or the best practices way of making our system the best that works ultimately for owners, because everybody here should be here to serve owners. Thank you.
Anyone else for public comment? Okay, I will hand it back over to the director.
Thank you, Amanda. So moving on to agenda item 3, that's agency presentations. I'd like to turn it over to the Administrator Chandra as well as Ombudsman Merriweather. Thank you.
Good morning again. Shrat Chandra, Administrator for the Real Estate Division, and then Sonia is also available. So we'll just kind of quickly wanted to give everyone an overview of the Nevada Real Estate Division. Just a quick snapshot. Don't want to take too much time out here, but I think we shared a document, and if possible, I'll share my screen. And so we can just quickly go over this, these two slides. Can everyone see the slide? Perfect. So essentially, this is just a 2-page overview of the Nevada Real Estate Division. Primarily, one of our functions is licensing. So on the left, you'll see licensing of real estate agents, builders, developers, timeshares, appraisers, energy auditors. So approximately 41,000 licensees through 4 or 5 sections of law. We have an education section in the real estate in the real estate division, and also a compliance section. Similar to CIC, we have a real estate commission that oversees disciplinary matters, and also a commission of appraisers. So that's essentially, in a nutshell, what the real estate division does on the licensing side of it. On the ombudsman side, on the left, you'll just see a quick snapshot. Obviously, we are growing. HOAs are something that is just inherently part of Nevada. We've kind of increasingly have added more and more associations, and also the units that are registered under them. So these are essentially 2025 numbers. I mean, I know there have been some changes since then, but just a quick rough snapshot. And also we license community managers. So essentially community managers are licensed through the division and work in HOAs. And then again, the role of the ombudsman and all the areas that cover CICs. And we have the 7-member body of common interest community commissioners that oversee disciplinary action, provide regulatory adopting regulations, and also provide some advisory guidance to the division on what's happening in the community, because most of the members are part of the community and represent different areas. We have a CPA member, we have a attorney member, we have board members, we have just regular homeowners as part of that CIC committee. So that's really the overview of the division. We'll probably jump next to Sonia. We'll talk a little more in depth about the Ombudsman's office and kind of some of that functionality. And then we'll kind of leave it at that. And then, of course, if task force members have questions, please feel free to ask.
All right, thank you. Good morning, everyone. I'm going to share with you my screen also and present to you an overview of the office and the different sections that we have within the program. Can everybody see that screen? Okay, great, thank you. I do thank you for the opportunity to present this information about the office, and today I'll just walk you through the mission, the programs, and the resources available that supports our common interest communities. The Office of the Ombudsman, oh, it didn't click over, huh? Oh, there you go. Okay. The Office of the Ombudsman for Owners in Common Interest Communities and Condominium Hotels was created and established in 1997 with the passage of Senate Bill 314. It was created to help homeowners and board members better understand their rights and responsibilities by living in their common interest communities. Our mission is simple and essential: to provide a neutral and fair venue that helps homeowners navigate issues that may arise by living in common interest communities. Our work spans several key areas. We have homeowner assistance. Through education and training, we help homeowners and board members understand their roles, the responsibilities, and obligations. Claim processing. We manage the Alternative Dispute Resolution Program for disputes related to the interpretation, application, or enforcement of the governing documents and changes in assessments. Investigations. We administer the intervention affidavit process and the statement of fact process for community managers and reserve study specialists when allegations of statutory violation arise. Then we have our forms and registration. We collect information from all of the associations throughout the state of Nevada. Now we'll look at the education training department. And what we know is people often turn to government agencies after something goes wrong. What we want to change that by offering education opportunities and resources that make it easier to stay informed and avoid issues ahead of time. We offer in-person and online classes, conduct outreach presentations at associations, and have a wide variety of online resources, including brochures, cheat sheets, templates, FAQs, newsletters, and an education manual. Although even with our best efforts, disputes will happen. So when they do, it's important to understand the right pathway to take. Our office provides information and education regarding processes so people can understand and know how and the correct pathway to handle their problem effectively and efficiently. For disputes involving the interpretation, application, or enforcement of the governing documents or assessment changes, the ADR program is the correct pathway. Parties may choose mediation, where a mediator helps the parties come to an agreeable solution, or they may choose referee, where a licensed attorney reviews the facts and renders a decision. Our office coordinates the assignment of the claims and then issues a letter of completion should either party wish to pursue court action. You may be thinking, well, what if the complaint is not about the governing document? When allegations involve potential violations of NRS NAC 116 or 116B, the intervention affidavit process can be used. The office receives complaints in many forms, such as walk-ins, emails, calls, referrals from legislators or other state agencies. Often, effective communication alone can resolve some of the misunderstandings. This may involve making a phone call, gathering information to provide to the complaining party, or sometimes it's just bridging the parties together via a Teams or a telephone conference. Or it may result in filing an intervention affidavit, better known as an IA or Form 530. This slide shows you the steps that an IA may take once an affidavit is received. Once an affidavit is received, the first step is the initial review. These steps ensure that the affidavit meets legal requirements and to determine whether a conference or an initial investigation is best. The outcome could result in either a conference or finding letters being sent to the parties. Compliance review. If the allegations are conferenced or after the initial investigation, the allegations and documentation reflect that an investigation by compliance is warranted. Complaints with potential violations are referred to the compliance section. Enforcement. A complaint forwarded to the compliance section is further investigated, and the possible outcomes may be a letter of instruction, a compliance demand letter, or referral to the common interest community. Lastly, when the allegation is about a community manager or reserve study specialist, a statement of fact is the process that's applied. A community manager holds a certificate under 116, whereas the reserve study specialists are registered with the division and are under 116B. Both follow the same investigative pathway through compliance. The potential outcome after an investigation may include corrective action, an administrative fine, suspension, revocation, or referral to the CICCH Commission for disciplinary action. I hope this overview gives you a better understanding of the broad and essential work that this office performs on behalf of Nevadans. From education and dispute resolution to investigation and regulatory oversight, we are committed to supporting well-functioning communities. Our goal is not only to resolve disputes, but to empower communities with knowledge and tools to prevent them. And at this time, I thank you for the opportunity to present this, and I'll just segue quickly into the Ombudsman Assistance Report. And this gives you just a general idea of what the office is doing in fiscal year 2026. As of October 31st, 2025, if you look at the upper left-hand corner of the report, there were 103 constituents that received assistance as walk-ins and 135 resulting from phone calls. The assistance provided is usually, at this point, just the staff explaining processes and answering general questions. Now, looking to about the middle of the report, you'll see that there have been 66 intervention affidavits filed, 29 affidavits carried over from fiscal year 25, in addition to 45 complaints that were received by walk-ins, phone calls, emails, and referrals. Of that 66, 7 affidavits were sent directly to the compliance section because of records request or the nature of the allegations, which could be previous CDLs that were issued or LOIs. 1 affidavit was referred to the ADR process, and that's because it was about a governing document matter and the parties had exhausted all available remedies. As a result, there are 132 assistance opportunities for the Ombudsman's Office, all after After all efforts taken, 13 affidavits were, with potential violations, were referred to the compliance section for further investigation. And if you look at the bottom right-hand corner of the report, 100 cases concluded, resulting in 58 conferences. 42 cases received a finding letters, and that left 19 cases that were active for that period of time. I thank you for your time.
Do we have any members of the task force that would have any questions for the presenters? Okay. Moving on to agenda item 4 for discussion of possible action. A little bit of housekeeping here with respect to what we're envisioning here. So we have very specific issues that we have listed on the agenda. We'll do this with the agendas moving forward as well. The idea is as we have these discussions, if there's areas that the task force is going to recommend action, we will call that out in our task force report. So once we conclude our task force meetings, we will at the staff level be producing a report. That report will include recommendations that will inform the legislative process in 27. It'll be shared with the legislature as well as the governor's office. And so, you know, when we say action on the agenda, it's just that it's recommending a specific change to statute, or perhaps that a regulation be looked at the administrative level here within the department. And all of that will be aggregated as well as summaries of the task force meetings for the report. So moving on to item number 1 under agenda item 4, and I'll turn it back over to the administrator.
Thank you, Director. CICCH Chandra, Administrator for the Real Estate Division. Again, so discussion items under 4. I think one of the things that we kind of talked about is from a task force perspective, at least start the discussion with some of the things that impact homeowners. So we've got generally, the way I look at this is we've got homeowners that are very actively involved and engaged. And then you've got the 80% of the folks that are just living in HOAs and kind of want to understand what their rights and responsibilities are, and essentially are not that engaged. And so part of Sonia's presentation was to kind of go into trying to educate and engage that 80% or of the folks that are not actively engaged in their HOAs. And some of the things that the Ombudsman's office sees are practical matters, sometimes things that are kind of in statute that just don't align, or things that we believe are things that this task force can kind of look into. And again, you know, 116 is very nuanced, and once you scratch the surface of it, there's all these possibilities. And so we wanted to narrow it down to a point where we could have an active discussion with the task force and then kind of maybe move towards some kind of recommendation or guidance as far as how we want to kind of proceed. So the first thing, and the division tried to kind of capture essentially what the situation was. And if you look at the discussion item on 1, I think the concern really is from a homeowner's perspective, them being noticed on certain actions that happen within an association. That's really the big picture. And so specifically, it's capital improvement. So if there is a capital improvement that is performed, the idea here is really to educate or at least notice the homeowner when that process happens. So if you look at the issue we've tried to break down is, I think there might be some opportunity in improving the language, or at least improving our understanding of what exactly is a capital improvement, whether, and again, you know, we could discuss about whether it's a definition of capital improvement or just take it a little further to say, are we informing the homeowners when we make these big financial decisions in regards to their homeowners associations? And so essentially our thought is the noticing of these big decisions have to follow some kind of a protocol. And so there might be some areas where associations are not, or misinterpreting or looking at it in a way where if it is not strictly what they consider a capital improvement, then a notice may not be necessary, especially in the context of when they're using funds that are not designated for capital improvement. So that's generally what we've tried to summarize here. And I don't know if Sonia or Crystal want to add anything more to this, but this was essentially a way to hear from the associations and members of the public and task force members on, does this make sense where the division is going, or at least our thought process, and any kind of discussion around how we can improve this.
This is Sonia Merriweather. Sharaf, no, I think you summed it up well. We do get calls in questioning whether certain projects within the communities are capital improvements as opposed to an upgrade to an existing amenities that in the community, and when does it now cross the line of just being an upgrade and now should be deemed to be a capital improvement. And so this is why we brought this particular statute up for discussion.
And this is Crystal Keegan, attorney for the real estate division. I don't have anything to add, just to point out, which I'm sure we're all aware, and NRS 116 doesn't define capital improvement. It doesn't define structure. And so without that guidance, I think there is potentially some issues there. And then also what we have seen under the issue for this discussion item, the second bullet point, isn't requesting owner funds. We often see when the use of surplus funds or other construction defect funds, as far as not doing the 21-day notice requirement because owner funds aren't being requested.
So Michael, if you want to go next, and then we'll do Jason and Donna.
Thank you. I'm kind of curious because it seems to me that both the commission and the division have the power, the statutory power to issue a regulation that defines what's a capital improvement. And I was just going over again 116.623, the division shall provide by regulation for disposition of petitions for declaratory orders and advisory opinions as to the applicability or interpretation of any provision of this chapter or chapter 116A or B. So I guess it seems to me that the real estate division, through either the division or the commission, already has the power to define this. I think it's a good idea. I agree with the proposal to clarify this, but I think the division or the commission already has the power to do that.
Jason, you're still muted.
All right, well, thank you. I'll jump in. So from a practitioner standpoint, I would agree with where Michael's coming from, but also as a practitioner, that's the trip up for us, is defining when it becomes capital. And I think we have no problem meeting the notice requirements or anything of that nature necessarily. It's what does the project that's being proposed trigger or does it qualify as a capital improvement? I think if we get a working definition of that is reasonable, I don't think the managers out there, the management companies would have a problem, or boards for that matter, would have a problem meeting the notice requirements so long as we can get a good working definition of when a project becomes a capital improvement.
Donna, we'll go to you next, and then we have Mark and then Doug.
Okay, thanks. I agree. I think we need a definition of capital improvement, which I, in advising my clients, would generally define, and when I draft governing documents, I generally define as a new additional major component of the common elements, to distinguish that from major components of reserves, which are generally treated differently. So if, for example, I need an assessment in order to adequately fund reserves, that does not require a special notice, that does not require a vote of the membership. Whereas in many cases, capital improvement assessments do require membership votes. So I think it's important that we clarify that capital improvements are new and additional items that we're adding. I also want to point out from, a practitioner's standpoint that upgrading existing components shouldn't really be considered capital improvements. If I'm going through my community and I'm upgrading the lighting and I change and it's, incandescent or whatever it is, and I upgrade it to LED, that's not necessarily going to cost more money, but it could be more efficient in the end. So I would like to see us arrive at a definition which gives some clarity between major reserve components and capital improvements being new and additional items to the common agenda, and to make sure that, we are treating those separately, which means we can't take just an IRS definition of what a capital improvement is, because that would include reserve components. So those are my major concerns about any changes to regulation or statute concerning this particular provision.
Mark, you're up.
Thanks. I've written out some thoughts on this. A strict interpretation of an improvement that is not a capital improvement would be actions that preserve existing common elements in their current condition without materially enhancing value or extending useful life beyond the original design. Unfortunately, this definition severely limits the application of good business judgment and common sense. Boards should have the flexibility to make use of advancements in technology and materials, and should have the ability to extend the useful life of components when it makes practical economic sense, without the burden of requiring a vote of the membership if that applies. After all, the membership already elected members of the board to make such decisions and be practical stewards of association funds. At its core, non-capital improvements are maintenance level actions that preserve what exists, while capital improvements are transformative projects that materially change or enhance common elements. I would recommend the following definition. Non-capital improvement maintenance expenditures mean any repair, replacement, or enhancement of existing common area components undertaken by the executive board for the purpose of preserving, restoring, or maintaining their intended function. Such expenditures may include the use of new technologies, materials, or methods that improve efficiency, durability, or sustainability of the component, provided that the work does not materially alter the size, scope, or intended use of the common element, nor constitute the addition of a new facility. These expenditures are considered part of the routine maintenance and are funded through the association's operating and/or reserve accounts, rather than requiring special assessments.
Thank you. Thank you, Doug. You're up.
Thanks, Chris. Real quick, good thoughts all. One, just additional nuance to maybe consider where we're working in the gray areas, the margins on some of these definitions. I think the bigger issue is less probably the nature of the physical work that's being performed than it is the dollar amount that's at issue or potentially being expended, at least reading through some of the comments and what I've heard. And so I just wonder if including somewhere in there a backstop of, it's less about whether or not it's a capital improvement by definition under IRS, rules, or if it's depreciable asset or whatever, and more about the amount that the board is talking about spending. And so just query whether or not, as we come to some resolution on a new definition, if it's a capital improvement or any, enhancement to a major component of the common element that is in excess of these dollars above a budgeted expense that was already approved and voted on at the beginning of the fiscal year or something like that. In other words, using a dollar amount or a percentage of the assessment that we're talking about as a backstop to say, okay, whatever it is, guys, if you're going to spend this much, you better go out and talk to people and get their sign off. It's just the right thing to do to make sure that folks feel like they have a chance to chime in before their pocketbook is opened up. So.
Thank you, Doug. Donna?
I guess to Doug's point, I would just say, let's not make it a flat dollar amount, because then we run into the problem of inflation eroding the value of that flat dollar amount. So to the extent that anything is going to be put in about a dollar value, let's make it a percentage tied to something where, you know, we won't be back 5 years from now saying, oh, we need to increase this amount of money.
Jason, go ahead.
Also to tag on to that, Mark's definition, or that latter definition was right on the money. You had me all the way up until reserve, because I think that falls into a completely different animal. You know, if these are going to be funds paid out of operating and or through, you know, an assessment of some kind, I think reserve is its own animal and needs to be left out of this particular conversation. Just my opinion.
Sharath, did you have something you wanted to add? I saw you came off of mute.
Thank you, Director. So I think this is exactly the conversation we wanted to have, really, because our concern, and this is the way it comes through the Ombudsman's offices, we're trying to address kind of the public feedback, or at least the complaints that come through the office. And a lot of times it is about that, like I think Doug kind of touched on it, it's that noticing, being aware of what's going on. And I understand Mark's point is, you know, it's a function of the board and they need that flexibility to make these decisions. But the Ombudsman's office is kind of caught in that in between, where somebody, and it's just an opinion, some people feel like that is or should be a capital improvement, or at least a dollar amount, or whatever it is, and that the notice needs to be provided when these decisions are being made. And on the other side, it's a matter of, you know, functioning of the board and a smooth kind of, you know, flow of how these decisions are made being interrupted by these notices and these extra requirements kind of, you know, handicaps a lot of that process. And so that's kind of the idea behind this. But really, and I think people touched on this very earlier on, is whether the larger definition has to be looked at. And Michael talked about it in the beginning, whether the division has the authority. And this is where we wanted it to be a task force discussion, because without that engagement, if we make an advisory opinion or regulation without having this discussion, I think we'd be handicapping ourselves in coming up with a solution. So, and that's kind of, and then the decision whether this needs to be a statutory change, because we would like some kind of a statutory action, just because it does allow lawmakers to be engaged in this topic, and at some point we could draft up regulations. But really the question is whether this is a statutory kind of a direction we want to go in or not, is also some of the things that we wanted to discuss. But I think this is a great start.
Any other comments on item 1 under agenda item 4? And what we'll do too, just another housekeeping point, is you know, we're recording and transcribing everything, so obviously we'll have minutes. But what we can also bring back in working with Sharath and team is suggested language for either statutory change or a regulatory action. So that way the task force has the opportunity to kind of take another stab at it before we finalize what may be recommended in the final report. So moving on to number 2 under agenda item 4, and I'll turn it back over to the administrator.
Thank you, Director. Sharath Chandra, administrator here. So the second item is, again, stepping back and looking at it from a division and the Ombudsman's office perspective, it felt like 1 and 2 is where there was a lot of confusion with homeowners and how associations were looking at this language. At least our perspective, and I know we've got a lot of public opinion and kind of concerns about what exactly the intent behind this is for us, it's just a clarification of those 2 steps, 1 and 2. It felt like they were repetitive, and then some of that overlap was causing a little confusion. And so our goal was to really get thoughts on just combining 1 and 2 into one process, which is essentially homeowners notice, and then they get on the agenda. Part of it also is, and this is again, I always want to contextualize this is again things that come to the ombudsman's office with questions and concerns. And so that's kind of our perspective on this is it clear on what's allowed and what the homeowners can do as opposed to individual processes within all these associations. And the other thing I just wanted to add to this was, I think it's important to, as we consider this, there's also a section is to look at this in context of NRS 116.31085. And I think Crystal can kind of dive in a little bit about that too. Essentially, this is what we're talking about here is really the ability of a homeowner to put the request to be put on the agenda for discussion. And that's kind of that. And then there's NRS 116.31085 that is a little more deep dive into exactly what can be done in executive session and not. And so I think that's really the context of the discussion here. But on this topic, essentially, the division's goal is to provide clarity on the process of getting something on the agenda of a board meeting. And I think 1 and 2 sometimes overlap and confuse matters. And so that's the direction we wanted to go in. Crystal?
Thank you, Administrator Chandra. This is Crystal Keegan, Division's attorney. So that's right. I would say NRS 116.31087 as written, it's just really poorly written. It's super clunky. And so what the division has proposed in combining 1 and 2 does not diminish the rights of a unit owner to request that a community issue or matter be placed on an executive board agenda, and that they get the 10 business day notification that it's going to be placed on the agenda. So in that regard, but as Administrator Chandra stated, 116.31885 is important to this discussion. And as we reviewed the August 2020 task force minutes, we saw this also come up as far as what matters would go into executive session and what matters would otherwise be, in open session. And so in 116.31085.3, it provides what matters would be considered confidential or going into that closed session for discussion. That would be attorney-client privilege matters, other character, conduct, misconduct, professional competence issues. And so that's fairly stated right there. And so those 2 statutes work together as far as any concerns, as far as what matters should be discussed openly and what matters would go into executive session.
And if I could add to this, Sonia Merriweather, again, just the consolidation of the 2 sections under the statute, and a bigger picture of this statute also is the intent of what the unit owners expect when they do notify the association via writing that they believe a violation of the governing documents has occurred. And the expectation is basically The unit owner believes that once I notify the board, that they will put it on the agenda and that there will be discussion that takes place at the meeting. And what we're hearing is that's not happening. Basically, the matter is being placed on the agenda when it's placed on the agenda, and the board amongst themselves have determined at the meeting that there's no discussion to take place, and then the unit owner doesn't get an opportunity to have dialogue with the board. And so there's a gap here of what is listed or what's stated in the law and the expectation of what the unit owner believes they're entitled to once they notify the board of an allegation.
Any comments from task force? Mark?
Leaving the language consolidation to the attorneys, the underlying purpose of NRS 116.31087 is puzzling. To give an example, if I have an issue with the conduct of my county commissioner, I can't force the county to place my grievance on the county commission meeting agenda. There's already a built-in mechanism to air a citizen's concern, or in the case of CICs, a member's concern with the conduct of the board, and have it made part of the permanent record. That is the homeowner's open forum period afforded to the membership at every board of directors meeting. Reading through the public comments for today's meeting, a concern is the ability or lack thereof to compel the board to engage in open discussion regarding the alleged complaint and provide the member with a substantive response. One can imagine a perfect world scenario where there would be earnest back and forth discussion and both sides would emerge with a better understanding of the issues and a clear path toward resolution. But in reality of our imperfect world, a board of volunteer laypersons would be foolish to openly discuss perceived violations of the law that may or may not be credible. Such a discussion could inadvertently legally jeopardize them personally, jeopardize the association's D&O insurance policy, and possibly put the association as a whole in legal jeopardy. Further, I can see where this statute can easily be misused to obstruct and distract the board from carrying out its normal business of making decisions on behalf of the association during one of the few times a year it has to meet and carry out such business. It seems to me that if a member has a concern about possible NRS 116 violations, it ought to be brought to the association's manager, who handles the day-to-day operations and can route the complaint to the association's counsel if need be, so the member can get a proper response by the professionals the board has engaged to handle such matters. And if the complaint is legit, those same professionals can advise the board as necessary.
Thank you, Mark. Donna?
I support everything that Mark said. I don't see any problem with, combining sections 1 and 2 in terms of clarifying the notice that, if you get a complaint that alleges a violation, then from management's perspective, you have to move forward to put that on the agenda. It's clunky as written. Crystal's absolutely right. But when it comes to a dialogue or discussion at a board meeting, an open session board meeting, which is being recorded, it's unrealistic to think that that can occur. The owner can certainly make their comments during the owner comment period. The board might have, a statement to make in response, but there is not. If the expectation is a dialogue to work to some kind of resolution, I would never recommend that a client of mine engaged in such a dialogue. A written response would be far better and safer for the association and its insurance. So I agree with Mark's points, and I think we need to moderate the expectations of what this particular statute is going to achieve.
Thank you, Donna. David?
Yes, I have a question, and that is there a minimum matter of evidence, shall I say, in an accusation to bring before the board? Or can I bring an accusation this month about this and that month, next month about this and another one? There should be some minimum evidence before even bringing the accusation. But I do agree with Mark that it should be handled by a professional and not in a, as Donna said, an open board meeting, because the accusation could be a probe or some part of a discovery process to get the board to commit to something that they shouldn't. Thank you.
Crystal, did you have a comment on David's remarks?
Just briefly, and just also to clarify something, thank you, Dr. Sanchez. So under 116.31087, it does say that written complaints are confined to alleged violations of the provision of the chapter or the governing documents. And then I just also wanted to clarify that there's a distinction between association boards, which are often nonprofit, set up as nonprofits, versus like a county commission, which are public bodies. So I just wanted to clarify that. Thanks.
Thank you. And Jason.
Thank you. I so far agree with everything that's been said. Donna kind of beat me to it a little bit, because I think what this area has been void of is some sort of formal response when it's all over, something in writing back from the board to the complainant, that either and again, for whether it be for insurance or for legal purposes in the future. But so often as an attendee at these meetings, and I've done a couple of these over my career, where it'll come up on the agenda, the board recognizes that the complaint came in, and they go, does anybody have anything to add? No? All right, next agenda item, and on it goes. Because no one wants to discuss it in that kind of a forum. It's certainly uncomfortable. And they just gloss right over it, generally speaking. And then the homeowner's not really ever notified in any kind of formal way what action or non-action was taken as a result of their complaint. So I would love to see language of some sort of formal response being required after it's handled, be included with whatever we come up with.
David, I see that your hand is still up. Did you have a follow-on comment?
No.
Okay, great. Administrator, do you have anything you want to add on this one?
Thank you, Director. Only that I think there are two underlying issues here, and ours is more clunky language, clarification and cleanup of that language. Again, from a practical matter, what boards do, that's a good discussion to have, because ultimately the goal is to allow some kind of a mechanism for homeowners to put this on the agenda, or at least have a discussion with their associations, understanding that no one wants to do that in a public forum. Whatever those policies are, the division doesn't want to get into that kind of a role. But this was, yes, clean up this clunky language, because the situation could happen where somebody thought that they did send something to the board to be put on the agenda, and then you read two, and then they go, well, no, you should have told us again to inform us to put this on the agenda. And I think that's where the confusion is. And so if we can clean that up, at least that's the first step. And I think Jason brings up a great point, is maybe there is an opportunity to then have something sent to the homeowner about what was the resolution, or like Donna said, they would prefer something in writing to provide to the homeowner. Maybe there is that follow-up that happens after the meeting as to kind of whatever that decision is, or whatever that is. Maybe that language could be added on, but essentially ours was to clean up. And if you look at that number 2 at the bottom, suggested language, that was really the intent. The intent was not to change the focus of the statute or change the intent of the statute. It was essentially to clean it up. That's at least initially our perspective, and hopefully when we have that discussion, if there's something else that can enhance this process, we're happy to look at. But I just wanted to make sure that that was clear. Thank you.
Thank you, Administrator. Are there any other comments on item number 2 under agenda item 4? Oh, Donna, sorry.
I think we ought to acknowledge that when a board gets a letter like this, that is alleging violations of the governing documents or NRS 116, it's typically the preliminary step to filing an intervention affidavit. And the fact that it's getting onto a board agenda for a public discussion is perhaps an add-on to what is essentially the preparation for filing a complaint with the real estate division. Typically, we would advise our clients to respond to that complaint in writing, on the idea that it is going to become part of a record of what's going to be submitted to the real estate division in response to the ultimate intervention affidavit. So this is not so much to a change in the statute as to make sure that we're in recognizing that it's one more step on the path of what's coming to the real estate division. Since owners have their opportunity to raise these same complaints during the owner comment period, that the board is violating the governing documents or the law, I have to question what the value of this statute is to begin with, and whether it should even be part of NRS 116. But that's a bigger discussion than we're probably capable of handling in this format.
Thank you. Any other comments on part 2 of agenda item 4? Okay, seeing none, moving on to still under agenda item number 4, number 3, Administrator.
Thank you. Brad Chandler, Administrator for the Real Estate Division. So the last one is, and again, I always feel compelled to kind of put a little context around the discussion for this item. I think, again, this is based on feedback we get from the Ombudsman's office, complaints that come through the office, concerns, questions. And so this was a thing that that comes up more often than not. And the discussion is when a board decides to prohibit somebody from using their facilities or, the common elements, I think it's important that we put a time frame on this, specifically on this. And again, I don't want to open the can of worms on definition of reasonable time, and I don't, because it comes up in several parts within 116. The idea here is not to confine reasonable time or restrict the homeowners associations from saying what that is, depending on the context. But I think when it comes to shared facilities and things that homeowners use, there's got to be a little more specific timeframes around the use or not restricting the use of those common elements. And so I think that was what we wanted to bring forward, to see if there was any thought on how we could kind of improve or maybe put a cap on the max amount of time that a association can restrict someone from using common elements, because ultimately you live in an association because of part of the amenities, and that comes with living in an association. And I think that's one of the concerns from the Ombudsman's office perspective is, restricted for a year, what is reasonable? And so I think from the use of facilities, I think it's important to have a discussion around timeframes. That was really the idea behind item number 3, and happy to hear either Crystal, if you have anything to add to this, or Sonia, and then we'll kind of go around.
This is Crystal Keegan, the division's attorney. Thank you, Administrator Shonda, for the opportunity to elaborate. I agree, of course, with everything you've stated. In reviewing this, my position was that associations themselves are probably in the best position to define reasonable time to reflect their particular needs and expectations of their own communities. And that's supported by what we see in the statute, and they can amend its governing documents, particularly its rules. And as far as the division, we can offer support by issuing non-binding guidance through an advisory opinion to help communities apply this more consistently. But defining reasonable time, rigidly defining that, I think is not in the best interest, but perhaps it could be, if we are going to embark on that, it would be based on factors very similar to what a court would consider when, determining what is reasonable, looking at the severity of the violation, is safety risk, property damage, harassment, is it a repeat offense, the history of prior violations by the same owner, whether the owner corrected the issue, and just consistency with how other owners are being treated, etc. So I think there's a lot of discussion to be had on this one. Thank you.
Thank you, Crystal. I see we'll do Michael, and then the ombudsman, and then Mark.
Thank you. First of all, I do again think this is an area, I agree with what Crystal Keegan just said. I think that makes a lot of sense to me. And again, it is an area where the commission could create a regulation. And in order to create a regulation, there needs to be public hearing and input under the Nevada Administrative Procedure Act. The other thing that when I read this again, I was really struck by, it's interesting that the focus is on use of the common area, but the statute is very, very broad. I mean, it violates any provision of the governing documents of an association. That is way beyond just misusing the common area. And so maybe there's a way to address that particular violation in a different way. The other thing that when I noticed how broad this was, I went to look at the uniform law and I was surprised, surprised at what we have, that you can prohibit the owner from voting. And in looking at the uniform law, that's one of the things that the association cannot do. It cannot suspend a unit owner's right to vote or prevent a unit owner from seeking election. It does seem that prohibiting somebody from voting is a punishment that seems like way outweighs any violation. Thank you.
Ombudsman?
Thank you. Sonia Merriweather, I'm just going to add another layer onto this also for consideration as we discuss this. Some of the sanctions and prohibitions given to unit owners not only extend for a period of time, sometimes the hearing notices will also say, if you commit this violation again in 6 months, even though it may have been cured, we will impose this same penalty against you without further due process. So I want to, this was brought to the table because the way different boards are applying this particular statute, again, it depends on the board and their discretion, but it is broad, and reasonable is not defined. It is one of the duties that the board does have to make that determination, but you can see it kind of runs the gamut of how different boards apply this authority that they have. Thank you.
Thank you. Mark?
Yeah, the two subjects are raised with the stated issue. what is a reasonable sanction and what is a reasonable time for the sanction to remain in effect. Regarding access to common areas, it is not out of the question of the association's manager to be granted the authority to immediately suspend a unit owner's access to common elements such as a pool or clubhouse, provided the procedures for such an action are decided by the board in advance, communicated to the membership, and publicly posted at least 30 days prior. Such a notification should clearly anticipate and define the violations that would be addressed and the temporary sanctions the manager can invoke, along with the time frame and procedure for the matter to be further adjudicated by the board or designated authorities such as a community standards committee. Given that some boards meet just 6 times a year, a period of not more than 60 days to adjudicate the matter seems reasonable, given that the board and committee members are volunteering their time. Once heard, a reasonable time for sanctions to remain in effect should not exceed 90 days total, in my view. Further, deeming an infraction a health, safety, and welfare violation should be reserved for only the most extreme cases that truly put the community in peril, given that the ultimate penalty for unpaid health, safety, and welfare fines is foreclosure. Regarding suspension of voting rights, I'm reluctant to say that such an action should ever be taken, no matter the circumstance.
Thank you, Donna.
Thanks. I want to point out that a lot of CCNRs already address the reasonable time. It's not uncommon to find your CCNRs will say X number of days with regards to how long a member's privileges can be suspended. And it's usually expressed in, I'm going to make these numbers up, 30 or 60 days, or for as long as the violation remains uncured, or the assessments remain past due and delinquent. So not all CCNRs include these kind of provisions, but it's really not uncommon to find them. So I think in some ways this is self-limiting if you're thinking about the advisory opinion route. And Sonia Merriweather brought up the idea of recurring violations, and there needs to be a way for boards to address situations where you have owners who serially violate the rules, and they've been brought to a hearing and they have been found in violation and sanctions imposed, but then they continue to do it. And parking often provides a great example of that, where they are brought to a hearing and fined for parking in a space to which they are not entitled. They cure that for a week or two, and then they're found again to have repeatedly done the same thing. So if we're going to bring that in as an aspect of what we're discussing here, then I think some consideration needs to be given, because boards are not meeting on a regular basis to deal with these serial violators. Statutorily, they have to meet about 4 times a year. Meeting more costs them money. These are volunteers. So we have to keep that in mind if we're talking about the entire enforcement process and the sanctions which can be imposed.
Thank you. Administrator, do you want to add any perspective?
Thank you, Director Sandra. No, I think it's a good discussion. I think, again, this is something that we could take it as deep or kind of keep it narrowly focused. So our intent, again, was to kind of address that issue about usage of common facilities, and that's some of the complaints that come through the office. But I think folks pointed out that, Michael also made some good points. So I think that's something to consider, like an overall. And if most CCNRs, again, what we have to remember is we're trying to address something across the state. And so, some of the newer CCNRs, things that have been developed in the last 10 years probably address it. We also have some legacy things out there that don't. And maybe there is something that we could do from a regulatory or an advisory opinion or statutorily that can kind of address on a larger platform, this issue. But I think that's all I had. Thank you.
Thank you. All right, any last comments on part 3 of agenda item 4? Okay, moving on to still under agenda item 4, number 4, assessment of procedural gaps and potential stakeholder impact. This kind of goes back to a reference I made in my opening comments that we are doing an assessment across all of BNI on our internal processes and how they may impact our stakeholders and how we might enhance our processes to ensure better service delivery. So we just wanted to make sure that this was agendized, especially for the members of the public that are paying attention. Certainly, we are interested in hearing how we can improve. I don't know if there's any comments from anyone on the task force and from their experience about interactions with the division or any recommendations. Donna?
I would like to see an adjustment to NAC 116.585. Particularly subsection 2, that says the division may not submit any evidence to the commission or a hearing panel before the hearing, except for the complaint and answer. I think that as a procedural matter, that would enhance the commission's ability to understand material that's being presented at a hearing. If the parties could stipulate in advance to the evidence, and the evidence could be given to the commissioners along with the complaint and the answer, in my opinion, that would make the hearings more productive and certainly streamline the process.
Thank you. Oh, Crystal?
Yes, this is Crystal Keegan, the division's attorney. And so thank you, Donna Zanetti, for your comments. And so in practice, this is already occurring where in certain cases with voluminous documents, particularly in the audit cases, thousands of pages of financials, the parties have been doing a great job, particularly when the respondent is represented by an attorney, to stipulating to those documents and getting them before the commission so that they can review the documents in advance. But I would say there's also a caution here in providing the commission with documents in advance of a contested case and making any preconceived, decisions or opinions before heading into the commission. And I know Senior Deputy Attorney General Phil Sue and I have had a conversation about this as well. And I don't know if he wanted to chime in with any comments, but I just wanted to add that information into the conversation. Thank you.
Thank you, Phil Sue, for the record. Thank you, Crystal. Yeah, Crystal and I have talked about this at length. I've also talked about this with my counterparts over at boards and government. Stipulated documents, excellent, especially for status checks. We I think in practice do try to get those documents in advance, but it does come down to with those contested cases. I think though, in practice, I don't see a problem with that. It seems like if there were potential interpretation issues regarding the evidence, then we just would simply not stipulate to it. We're strictly talking about things that are factual, and so probably something that we could implement in practice. I very good observation there, Donna. And I think in practice, something that's already being done with other professional licensing agencies. I don't necessarily think that there is a problem. The only issue would be somebody as far as I can anticipate, somebody from the whole idea is that the commission rules on the evidentiary issues, even if the parties stipulate to it, they themselves there needs to be some kind of okay by them. So maybe we could designate somebody from the commission to accept those documents and determine that the stipulated documents are fine to provide. That's, I guess, the only procedural hurdle I can anticipate. It's not a big one.
Thank you. Any other comments for discussion here, this item? Okay, still under agenda item number 4, number 5, evaluation of ombudsman reporting protocols and potential improvements, recommendations for administrative reform to promote fairness, transparency, and accountability. Again, similar to agenda item 4, this was agendized so that we can also, in addition to allowing maybe task force members to weigh in, members of the general public that may have some recommendations. We wanted to make sure that they were aware that this was an area that the task force would be looking at. Looks like Donna.
I would like to see the task force take a look at the alternative dispute resolution process. We have certainly, when I came to Nevada as a manager, arbitration was the default. It converted to mediation. Any analysis that you do of the statistics just generally demonstrate that mediation is not resolving the majority of the complaints. Based on the statistics you present, there's an overall 13% success rate. It's costing about $1,100 per successful mediation. I think that arbitration provided a much better chance of actually resolving issues. But I do think that for it to be successful, we need to pay the attorneys and other professionals that have agreed to participate in the Nevada Real Estate Division program what they're worth. I mean, they're currently being paid about $166 an hour for their time. I know the one sole mediator and referee in Northern Nevada usually puts in much more hours than I believe he's getting paid for. So I would hope we could address that issue.
Thank you, Donna. Phil, did you have a
I
comment?
did. I think I'm not sure if it's something that the division needs to follow, but I will say the rate tables for, say, the AG's office, it actually increased from $157.04 to somewhere in the realm of $250 an hour now is how much the AG's office is charging the division. So if there is some kind of parity between that charge and how much would be charged by the division's assigned mediators, there's at least some precedent, I guess, is what I'm saying, by the market.
Thank you. Any other comments from the task force members? Administrator, did you
Director
have a comment?
Sanchez, sorry, this is Sharath, and I think just to follow up on this, I think even at the beginning of the meeting, I think Michael might have said this also, NRS 38 was an area that we wanted to look at and try to offer some improvements or some changes. Ultimately, our goal is, the homeowners walk away with some kind of a resolution or some kind of a process where they come out with a decision. Ultimately, I think it comes down to the monies. The division subsidizes a certain amount of these mediations currently. And so we are open to increasing whatever the dollar amount is under, reasonably to make sure that we have a process where we can look at different approaches and also compensate the attorneys for their time and all the folks involved. And so 38 is definitely something that maybe, Director, we put it on the next agenda as a discussion item, because I think that one is, I think there's a consensus that there needs to be something. There's a fiscal piece that the division needs to worry about, but I think we're willing to sit down and have a discussion. I know the AG's office has some resources from the courts. They have a program there too, similar to a mediation program, arbitration program. And so maybe there's a couple of things that can get lined up, but we definitely have to talk about NRS 38 and that process. So I think it might be definitely an agenda item for the next meeting.
Thank you for that, Administrator. Any other comments? Okay, seeing none, still under agenda item number 4, and this is under section B. This is for possible action, discussion, and decision to approve minutes August 19th, 2020 task force meeting. You know, I don't know that we need to approve minutes from the 2020 meeting, given that it was a different body with, well, some of the folks are consistent here, but not many. But one thing that is important is just making sure everybody had reference to the fact that there was a task force meeting that happened back in 2020 and was able to review those. I don't know if there's any items on that agenda. Sorry, my throat is hoarse today. On those meeting minutes, excuse me, that would need to be discussed today. Crystal.
Thank you, Dr. Sanchez. This is Crystal Keegan, the division's attorney, and I'll just have Senior Deputy Attorney General Phil Sue also correct me, or just let us inform all of us if my understanding of this is correct, because I understand we don't have a DAG from boards and commissions appearing here for this this meeting, and so I understood NRS 241.035 for proper record keeping, that we do need to approve the minutes, even though the former members aren't here to approve. And so I just wanted to confirm from Phil if that was his understanding. I just, I want to make sure we're proceeding properly. That's all. Thank you.
Thank you. Thank you.
Thanks, Crystal. Yes, kind of took the words right out of my mouth. If this is the same body reconstituted, yes, that prior is inheriting the powers of that prior body, it probably would benefit the continuity of the task force if we do opine, even if it weren't something that we ourselves had deliberated regarding, but that we do opine regarding the minutes.
Okay, thank you. With that being the case, I'll entertain a motion to approve the minutes from the August 19th, 2020 task force meeting.
Dr. Sanchez, this is Sharat, I'll second.
Michael, I see you have your hand up.
I did. I was just curious what happened with those recommendations.
Sharat Chandra, Administrator for the Real Estate Division. So that eventually ended up being SB 72.
Okay.
And I think the one item that did not make it onto that bill was the discussion that we just had on item, I think it was item 2. But most of the other recommendations made it to SB 72 and it actually passed.
All right, thank you.
So that was kind of the evolution of that task force.
Thank you.
We had a motion on the table to approve the August 19th, 2020 meeting minutes as written. Do we have a second on the motion?
Second.
Thank you. Task member Buckley, and all those in favor?
Aye.
Aye.
Any opposed? Any abstentions? Okay, seeing that, item passes. Moving on to agenda item 5, and that is a recap of decisions and next steps for the next meeting and expectations for upcoming meetings. So I know, Administrator, you mentioned that we have for consideration on the next agenda was NRS 38, I think it was. If my notes are correct, I was trying to keep track of the meeting and take notes here at the same time. Are there any other items that task force members would like to see on the agenda for our next meeting? Michael?
Yes, I would, and I don't know if it's possible, but Sonia and I spend a lot of time with the RAND attorney and researcher making recommendations to the state of Hawaii based on a number of state laws. And I suspect we can't take advantage of what their report was, but perhaps check in with the state of Hawaii and see what good ideas they had that came out of those discussions, because they did look at it, and that would be something appropriate for one state to ask another. One of the things that I know has been batted around, and we talked about it with the RAND researcher, was the idea of having professional board members or paying board members so that the associations are better managed. And I know it's a big issue, but it just seems to me that might be something worth talking about.
All right, great. Let's see, Donna?
I'd like us to take a look at NRS 116.1107, which is the eminent domain statute. To amend it so that boards of directors had the ability to convey common element to the state or another entity that has eminent domain rights without the necessity of that entity filing a lawsuit for eminent domain. We have numerous situations up here in the north where the Regional Transportation Commission needs a piece of common element. Everyone thinks it's a great idea. It's going to enhance safety, but the board's hands are tied short of the RTC actually filing a lawsuit.
Michael?
Yes, this is this affected me because I have two siblings who live in a association where there's a a golf course. And under 116, the association can grant easements. The board can grant easements without the approval of the members. And in a case where there's a golf course conversion, there's a potential, a lot of neighboring land that could be severely, the use could severely be changed, and the homeowners would not have any say in that. And I just bring it up. I don't know what the answer is, but it does seem to me that at some point, if there's a fundamental change in use or burden of use on association common elements, at some point there may need to be some greater level of approval.
Thank you for that. Any other comments? Good. Seeing none, moving on to agenda item 6 for possible action, discussion and decision on time, date, and place for the and the agenda items for the next meeting. I think we covered the latter part here with the agenda for next meeting. My suggestion would be that we convene again towards the end of February. I think we had Letty had done a poll, a digital poll on availability. If the task force agrees, we can do that again to find the common dates and times that everybody's available. And we'll get that sent out here pretty quick. But I think certainly would like to know from the task force if the end of February is sufficient time, if there's a desire to meet, in March or in January, or the cadence of meetings. I'd like to get some input from the task force on what the preference is. Michael?
I think February is great. I think we need to have some momentum, and if it's too far apart, then we'll potentially lose that momentum.
I see nodding heads. All right, great. Any other points on agenda item 6? Okay. Seeing none, we'll move on to public comment. Amanda? Agenda item 7.
Yes, agenda item 7, public comment, just as I had mentioned previously, no action may be taken upon a matter raised under this item of the agenda until the matter itself has been specifically included on an agenda item upon which action may be taken. Comments will be limited to 3 minutes. If you are making a public comment via phone, please call 775-321-6111. And the phone conference ID number is 735-112-509#. And we will start with Solomon. or actually, yes, we'll start with Solomon and then we'll move on to Mike Kosar. So Solomon, you may begin your 3 minutes.
Okay, thank you. And good job for the task force. I know it's been years since you've met. Owners like me are frankly skeptical of all of you, that you even care or that you'll even do a good job, or you're just here just to get paid. But I gained confidence from this meeting that you do want to refine processes, and you do. A bunch of you today did remember the citizens, the people, everybody in government is supposed to serve, and the owners vastly outnumber the amount of people in this meeting. They outnumber the boards. They outnumber all the attorneys. So I'm glad. It seems like to me you're not losing focus about who you're here to serve, and that's the citizens and the owners. Couple of comments on the violation. One thing I'd like to see in the future is the big thing that gets owners upset are violations. And I notice when violation notices go out, it is not the law that the appeal rights of the owners is included in that violation. So, the NRS 116 that says you have an option to have a public hearing. Now, from when I sat on a board, it's human nature that the owner gets a lot better, fairer shake at a public hearing, at a public board meeting, than a bunch of board members sitting around in executive session. It's so easy to hammer the owner unfairly than if you're there in front of the fellow owners. And so I'd like for it to be law that when a violation notice goes out, it advises the owner they have a right to a public hearing. And so the owner doesn't have to go digging through the NRS 116 to find that. And that would solve, I think, 50% of problems coming to the ombudsman. Paid board members, somebody brought that up. By all means, all of you want to get paid more. You're on the payroll. Attorneys just stated they want to get paid more. You get what you pay for. And I wouldn't want to be a board member to get rich, but you have, we all realize if you're paying people to do a job, they're going to do a better job. So I don't know what that pay rate should be, but of course, board members should get paid for their service if you want them to take it serious and do a good job. And the last thing would be insurance requirements. Right now in my 45-story building, if an earthquake happens, I lose half my investments. We have almost no earthquake insurance, but NRS 116 does not specifically address earthquake insurance. And Nevada is the 3rd most frequent earthquake state in the country. We have 10 earthquakes a day in Nevada, but yet NRS 116 doesn't address it at all. So I'd urge you to consider reform of that. Thank you for your time.
Michael, you can go next.
Yes, thank you. Let me start by reminding the commission, and I'm sure you're aware, the legislator actually made this commission, granted your ability to form for the purpose, I believe, to do more than just what the CICCH commission can be and should have been doing all along. As I listened to this conversation this morning, I was pleased by the conversation for the most part. I don't agree with all that was said, but I see everything that was talked about today well within the realm of what the CICCH commission should be doing all along, and frankly hasn't. So I'll use that as a lead in. What I would like to see this task force do is to take on that issue of why the CICCH commission isn't fulfilling what it was tasked to do in 2005 when it was first set up, and what it was envisioned by Senator Snyder all along as to be the oversight and policy person where this could be going on all the time. So I'd like to see that on the agenda for the task force. I'd also like to see reserves on there. That was mentioned briefly. That's a piggy bank that needs to be adjusted and talked about as to how reserves are used and abused. And then I'd like to see the business judgment rule. Why Nevada is one of the few is the only state that I'm aware of that has actually codified the business judgment rule when it comes to HOAs. And this, despite the American Law Institute has clearly says the business judgment rule is not appropriate for HOAs. So I'd ask you to do that and take a look at that. I'd also like to tell the board that this commission, what you're looking at in most cases is not the 90% of HOA boards that are doing the right thing. You're trying to target, unfortunately, that 10% that is not. Okay. And so a lot of this has to do with there's no appeal when you go to your board and your board makes a decision. A lot of the issues you discussed, particularly number 3, isn't a question of executive board decision. I believe that was inappropriate and overexpanded the use of the executive board, but it's a matter of notice. HOA owner has no way of informing his fellow homeowners of what's going on without some kind of notice out there. And if you can't put it on the agenda, it doesn't get done. And then I'll just conclude, consider this about what we're talking about when it comes to ADR. Right now, you can complain that your board is in violation of a statute or a directive, and there is no way to force them to give you any kind of answer whatsoever. None. That needs to be addressed and that needs to be fixed. And so I'd ask you all to take those on, particularly the NRS 38 and ADR. I think that is crucial. Without that being fixed, we've got a lot of work to do. Thank you very much.
Thank you. Anyone else for public comment? Okay, I'll hand it back over to you, Director.
I want to thank everybody for a successful first meeting and the members of the public that joined and those that offered comment as well. Wish you the best over the holidays. Be safe, and we will be in touch with you shortly regarding the next meeting. So with that in mind, I adjourn. Take care.
Everybody.